This video addresses DC divorce laws and procedures. In the District of Columbia, a divorce action can be filed and may be filed if there has been a separation that is for a period of 6 months, that's mutual and voluntary, or a period of 1 year if it's non-mutual or voluntary. In every divorce action, if applicable, 4 possible categories are considered by the court, considered and essentially litigated by the court if it's presented to the court: child support, child custody, alimony, and distribution of marital property. Child custody, the one that's the most important and the one that's most litigated, and rightfully so, is the determination. The legal determination is based on what is in the best interest of the children or the child, not what's in the best interest of the parties or the parents. There are about 9 or 10 categories that the court would exclusively consider in awarding physical or legal custody to either the parties. Those are listed on our webpage, familylawdc.com/child custody. With child support, it's a statutory-based guideline calculation based on the income disparity of the parties. It's far more simple than child custody to come up with the child support amount or calculation of the child support. With alimony, the court will consider the financial structure or capabilities of the parties, and there are 3 or 4 other elements the court considers in awarding alimony, and they are listed under our divorce page. Distribution of marital property. First and foremost, marital property is defined as a property that's acquired and accumulated during marriage. The court would distribute that property in a fashion that is equitable, just, and reasonable. And there are, again, 4 or 5 elements that are listed on the divorce page that the court would consider in coming up with the distribution that is equitable, just, and reasonable. But with divorce actions, more than any other category of family law, it is critical and paramount, and is really important for the parties, if at all possible, to have a meeting of mind, have a sit down through mediation or ADR, alternative dispute resolution, to narrow down some of the issues of contention or some of the issues that they must be litigated. If they can come up with the child support amount as an amount that's mutually agreed upon, or they can determine what form of child custody is workable, and then the court will consider the elements that are not agreed upon or mutually resolved through mediation, and it will narrow down the field of litigation and will save money, time, and energy, and is definitely recommended. For, again, more information about divorce laws in the District of Columbia, you can go to familylawdc.com/divorce.